How do you prove service connection for a veteran's disability claim using legal presumptions available to prisoners of war? Hi, I'm Mark Whitehead, an accredited veterans disability attorney. The veterans' claims for those who were kept as prisoners of war are given special consideration, since it's virtually impossible for former prisoners of war to provide medical evidence from the time of their captivity. Certain disabilities are assumed by the VA to be connected to this period of their service. The veteran is not required to provide any nexus of evidence, and there's no presumptive period. The current disability may have presented at any time after the former prisoner of war was discharged. Claimants are required to provide some medical evidence before becoming eligible to receive veterans benefits. As with other types of veterans claims, the veteran must provide medical evidence proving that the current condition is at least 10% disabling. But one additional hurdle in these cases requires proof that the veteran spent time as a prisoner of war. The claimant will need to provide documentation that the period of captivity was comparable to the POW circumstances during the previous times of war. Hiring a qualified veterans advocate to help with providing this documentation is always a good strategy. Which diseases make former prisoners of war eligible for the use of service connection by legal presumption? The VA's list of conditions that are eligible for the service connection by legal presumption for former prisoners of war is always changing. For some diseases, eligibility is determined by the length of time the veteran was in captivity. The VA has ruled that former prisoners of war must have endured at least 30 days of captivity for a range of diseases, including chronic dysentery, malnutrition, irritable bowel syndrome, and many other disabilities. Conditions including psychosis, any anxiety disorder, and most heart disease, stroke, hypertensive vascular disease, post-traumatic osteoporosis, and osteoarthritis, and in some cases frostbite, do not require any minimum amount of time in captivity, merely that the veteran was a prisoner of war for some period. The service connection by legal presumption can therefore be easily used to argue veterans' claims for former prisoners of war with these disabilities. The VA frequently changes the eligibility requirements for these diseases, so be sure to consult with a qualified disability lawyer in order to get the latest information. Also remember that former prisoners of war are eligible for many other types of veterans benefits, such as priority medical treatment, full dental benefits, and no copayment policy for all prescriptions. For former prisoners of war, successfully arguing veterans claims can be a way to get a small amount of restitution. More information on this topic can be found in my free ebook, Veterans Disability Claims: Strategies for a Winning Campaign. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular veterans disability issue. I'm Mark Whitehead. Thanks for watching.